Hello, my name is Nicholas Cowie. I'm a partner with the law firm of Cowie & Mott, PA, which is a firm that handles construction defect disputes on behalf of condominium associations. Today I'm here to talk about a recent Maryland case law in which the Court of Appeals held that a condominium association can be sued by its homeowner members for failing to file a timely lawsuit against the developer for construction defects. Now, in order to give you some background to this case, I thought I would discuss some of the responsibilities of condominium associations, especially when they take over control of the association from the developer. The condominium association has a responsibility to maintain, repair, and replace the common elements of the condominium. And with that responsibility comes certain duties. First of all, there's the duty to evaluate the condition of the condominium before warranties expire. And secondly, there's a duty to take reasonable steps to resolve and pursue construction defect claims against the developer. So first I'm going to talk about the first duty, which is the duty to evaluate the condominium. When a developer turns over control to the homeowners, the association becomes homeowner controlled. At that point, the association should hire an engineering architectural firm to evaluate the condition of construction, identify any problems, and bring them to the attention of the developer before warranties expire. A condominium association should not just assume that all problems or construction defects that might have occurred during construction were resolved or are non-existent. There's a lot of examples of this. For example, you can find construction defects that exist within buildings that may not manifest themselves for years until a leak occurs 3 years down the road. There may be situations where defects are obvious to expert consultants but not to homeowners. So when people say, why do we need a transition study or a deficiency report, whatever these studies are called, people call them different things, that's why you need to get them, because you can identify these things, bring them to the developer's attention while the warranties are still enforceable, and also, early on, a lot of these defects are easy to fix, but left unattended for years, they start causing property damage behind the walls. And sometimes people wake up 8 years later and find out that a little teeny problem that could have gotten that the developer could have fixed early on has turned into a huge problem. So the second responsibility of a condominium association is, once it knows about these defects, to take reasonable steps to pursue them with the developer. There was in a recent case, there was the condominium association, as I stated, in the case of it's called Greenstein versus Council of Unit Owners of Avalon 6 Condominium. In that case, the association was aware of construction defects but failed to take any action to preserve the claims. And then when they finally filed suit against the developer, all the warranties and other claims that they could bring had already expired. And this is because there is a statute of limitations that applies to all claims. Warranty claims, breach of contract claims, negligent claims, they all are of limited duration because of the statute of limitations, which is the time period within which a claim has to be brought or it's forever barred. And generally, there's only two ways to stop the statute of limitations from running. One, file a lawsuit before the statute of limitation expires, or two, get a tolling agreement from the responsible party. Now, a tolling agreement is just an agreement between two parties, which is kind of like a timeout, where you say, from this date until this date will not be calculated in the statute of limitations if we ever file a suit against you. It's kind of freezes things in time, and it preserves your bargaining power. Now, if the people in the Greenstein case had gotten a tolling agreement, they would have never been sued by their homeowner members. What happened in that case was, when the court dismissed the suit against the developer, the homeowners then had about $1 million worth of repairs, and they assessed all the homeowners for the cost of repairing the condominium. The homeowners then sued the condominium association because they had failed to protect their rights. Now, if they had gotten a tolling agreement in place, that would have never happened. Their claims would have been preserved, and if things didn't work out with the negotiations with the developer, they could have followed suit down the road. Anyways, one of the problems that I found with condominium associations is that they're afraid to find out what their rights are, because they're afraid that it's going to cost them a lot of money to hire an attorney to come in and evaluate their situation early on. An attorney that's versed in construction law should be willing to review your records, meet with you for free, and tell you what warranties and different claims apply, when they expire, why you should get a transition deficiency report if you've not already gotten one before warranties expire, and if that report reveals that there are problems, how to preserve those problems and how to properly negotiate with the developer, thereby laying out a complete strategy for you early on so that you don't walk into